Good morning, everyone, or whatever time of the day that this video finds you. We hope everyone is keeping well. We are focusing today's podcast on the issue of varying a maintenance order. So, we've been getting a lot of inquiries during the COVID period about the possibility of having a maintenance order varied. And I'm using the word varied because it could be adjusted in a number of different directions. That is to say, it can be increased, it can be decreased. There's also the ability to have it suspended for a period and later revived. There's the ability to have it extended so that you have the initial order stating a particular period that it would be in place for, the term of the order. You can ask for that term to be extended. Or you can ask for the payments, which are usually periodic payments, often done on a monthly basis, to be capitalized. And I did see an instance in court where the judge used the word capitalize, and I saw on a number of faces in the courtroom that there was a need to understand what the use of the term capitalize mean. And it simply means that instead of making periodic payments, you then have that maintenance payment made by way of one lump sum. So it's called a capitalized maintenance payment. Or you can ask for the maintenance payment to be discharged or terminated altogether. Now, we found that during the COVID period, there are a number of inquiries about the possibility, and in most cases, was about having the maintenance agreement adjusted downwards, mainly due to the fact that a number of persons lost their job during the period or their income was significantly decreased, so that the initial order was no longer possible, or it placed them under significant strain because they weren't able to meet the requirements. One of the things we always said or advocated to persons is that if, in anticipation of honoring those orders, you're able to tell, listen, in the next month or the next 2 months, I won't be able to honor that we would encourage you to petition the court in advance of that period where you would be in difficulty. So that you're not petitioning the court whilst you're in default of the order, but petitioning the court in anticipation of the difficulty, because you're always encouraged to come to the court with clean hands. And of course, when you go to the court, you would have to demonstrate to the court that there's a need for a reassessment of the order on the basis that there has been a significant change in your circumstances and you're not able to honor the order in the circumstances because things have changed. And you're asking the court to do a reassessment and consider what can be done in the circumstances, because there is obviously a continued need to care for the child, but you're not able to do it at the rate at which the order initially contemplated. We have also encouraged persons who are amicable with their ex-spouses or the biological parents or whomsoever they have been or entered into the order with, or the order is made with the other party to the order, to see if there can be a casual conversation and an agreement between the parties as to a reduction or variation. And have those parties come up voluntarily with their own order and then ask for that order to be made an order of the court. If, of course, in circumstances where the relationship between the parties are not amicable, then, of course, we would have to petition the court and you would have to provide evidence of the change in salary or the contemplated change in salary. It may be a letter from HR indicating that in the next 2 months your salary would reduce by 25%, at which time, if you still have a mortgage or a car payment and all these other things, that the quantum of the order would no longer be possible. And asking in the circumstances, even if it's a temporary reduction, for the court to consider a reduction for this time period until such time as the salary is either reinstated or you're able to get additional income. Now, I've seen the courts always asking the person who is required to make the maintenance payment to consider getting alternative employment. Do all that you can, because most times the court orders are based on what the child reasonably requires to be cared for. So any reduction would then obviously affect the quality of life of the child. So they always encourage, if you can get another job, if you can do something, even if it's virtually, to earn some additional income so that the order is not varied downwards. Of course, there would be no objection if the request is to have the order varied upwards. But in circumstances where the request is for the order to be varied downwards, then they would ask that party to see if they can exhaust all options first before the court is comfortable with a downward variation. So we are pleased or looking forward to hearing from you with regards to your experience on this issue. and always being mindful that the central focus of the courts is the welfare of the child, so that the figure needs to accurately represent what is in the best interest of the child. We look forward to hearing from you on this topic. Thank you, everyone.